Mary Beth Gettens, Managing Attorney with Gettens Law.
What do you do in event of a HIPAA breach? What are the breach notification requirements under the HIPAA Privacy and Security Rule? That is the topic of today's video. The HIPAA rule provides that following a breach of unsecured information, covered entities must provide notification of the breach to affected individuals, the Secretary of Health and Human Services, and in certain circumstances, to the media. Let's take a look. But first, what exactly is unsecured protected health information? Unsecured health information is protected health information that has not been rendered unusable, unreadable, or indecipherable via approved encryption methods, and the encryption code or confidential process for such encryption remains unbreached. So, if the breach involves information that is encrypted using approved encryption methods and the confidential process or encryption key remains secure, you're in the clear. No notification is required. If not, if the information is not secured or the encryption process key has been breached, here's an overview of the breach notification requirements. First, to individuals. Covered entities must notify affected individuals following the discovery of a breach of unsecured protected health information. These individual notifications must be provided without reasonable delay and in no case later than 60 days following the discovery of the breach. Okay, so let's look at the obligations to notify the Secretary of Health and Human Services. In addition to notifying affected individuals, covered entities must notify the Secretary of Health and Human Services via filling out an electronic breach reporting form on HHS's website. If the breach affects more than 500 individuals, the breach report must be completed without reasonable delay and in no case later than 60 days from the breach. If, however, the breach affects less than 500 people, the breach report must be completed annually, and the first report of breach must be no later than 60 days after the end of the calendar year. So, even if the breach is less than 500 people, covered entities still need to notify the Secretary of Health and Human Services. Okay, let's look at the media requirements. This only happens if the breach affects more than 500 people that are residents of a given state or jurisdiction. If that be true, covered entities must notify prominent media outlets via press release immediately or without unreasonable delay again, no less than 60 days of the discovery of the breach. But what about business associates? Do business associates have to provide notification? What happens in the event of a breach involving a business associate? Well, business associates must provide notices to the covered entity without reasonable delay and no later than 60 days from the discovery of the breach. And again, once notified, the covered entity must follow the notice requirements above to the individuals, to the Secretary of Health and Human Services, and to media outlets if applicable. Notice that all these requirements are 60 days under the HIPAA Privacy and Security Rule. Be cautioned, some state requirements are much less than 60 days. So take a look at your state laws and make sure that your state doesn't require a sooner notice. To hear about a case that involves notification of 90,000 individuals following a computer malware attack, visit our website at www.gettenslaw.com.
Again, this has been Mary Beth Gettens. I want to thank you for listening. Hopefully that's been helpful.